Welcome to Court Explainer, Court Helicopter Explainer, which continuously is bringing you the episodes about the Constitution of the Republic of Kenya. Why did the Court Helicopter decide to bring this one? It's because in 2010, two gentlemen read the draft Constitution. That is the late Raila Amolo Odinga and the late Mwai Kibaki. They're dead. And Kenyans were told, vote for yes. And they voted. Court Helicopter has now immortalized them by bringing it live to you so that you know your constitution as you're driving, as you're walking, on your phone, on your TV, on your screens, everywhere. Court Helicopter brings it to you, a summary of 25 episodes that deals with the Constitution of Kenya. Today we are looking at the most important office in this Republic of Kenya, the office of Director of Public Prosecution. They call it the ODPP, the Office of Director of Public Prosecution. It is found in Article 157 of the Constitution. In the old Constitution, criminal investigation was under the Attorney General. There was a department called the Criminal Wing of the Office of the Director of Public Prosecution under the AG. In 2010, Kenyans said, no, we need an independent ODPP. Previously, police officers could investigate. They come and arrest you. They process the charge sheet. They go to court. They prosecute. So the arrester is the investigator. He was the prosecutor, and the court was there. Under the concept of separation of powers, the theory of separation of powers was that you cannot be an investigator, and also be a prosecutor. Kenyans have seen the EACC saying we need to have prosecutorial power. EACC is an investigator. KRA is an investigator. The DCI is an investigator. The Inspector General is an investigator. KWS is an investigator. All these powers, originally, they could investigate and prosecute. But from 2010, the Kenyans created an independent office called the Office of the Director of Public Prosecution. Let us look at it. Remember, at one time, I myself, Wakili Danstan Omari, applied to be a Director of Public Prosecution. I went through the process. I lost at the interview stage, and the current Director of Public Prosecution, Renson Ngonga, was appointed the Director of Public Prosecution, a competent officer, a man of great achievements in the Office of the Director of Public Prosecution. We have had the Office of the Director of Public Prosecution. What is it? Let us go to it. 1. Article 157(1) establishes the Office of the Director of Public Prosecution. 2. The Director of Public Prosecution shall be nominated and, with the approval of the National Assembly, appointed by the President. So the Office of the Director of Public Prosecution, advertisements are done by the Public Service Commission. You apply. The qualifications are provided for who will apply. They'll be shortlisted. After being shortlisted, you appear before a tribunal. You appear before an interview panel at the Public Service Commission. 3. The qualifications for appointment as Director of Public Prosecution are the same as for the appointment as a judge of the High Court. For one to be appointed a Director of Public Prosecution, he must have been a judge for 10 years and above. He must have practiced law for over 10 years, either as a law lecturer or as a practitioner of law, either as a magistrate for 10 years, and that is the minimum qualification. Remember, he must also pass Chapter 6, what we said, integrity criteria. After this, once the name is approved, the name is taken to Parliament for vetting. After one has been vetted and succeeded, he is appointed by the President and given the powers to be the Director of Public Prosecution. He must be sworn in the presence of the Chief Justice or the Deputy Chief Justice by the President of the Republic of Kenya. 3. 4. What are the powers of the Director of Public Prosecution? The Director of Public Prosecution shall have power to direct the Inspector General of the National Police Service to investigate any information or allegation of criminal conduct, and the Inspector General shall comply with any such direction. Article 4 gives the Director of Public Prosecution the only person who can direct the Inspector General of Police. The President has no power to direct the Inspector General of Police. We shall be looking at that when we deal with Article 244 and 245 that create the Inspector General of Police Office. The Director General has power to direct the IG to investigate anything. You've seen it the other day. The family of the late Betty Bayo raised an issue that there is an issue. We do not believe Betty Bayo died without an issue. The Constitution has given the Director of Public Prosecution the following powers. In Article 157(4), the Director of Public Prosecutions shall have power to direct the Inspector General of the National Police Service to investigate any information or allegation of criminal conduct, and the Inspector General shall comply with such directions. The Inspector General is an independent office that does not take directions from anybody, except from the Director of Public Prosecution. Only the DPP can direct the Inspector General. Remember, the Inspector General will be dealing with it in Article 244 and 245. He cannot be directed. Not even the President can direct the President. You have heard most of the time the President tell you that is an independent office. Kenyans created and said the police should be independent. Let me bring two examples. After Jeff Mwathi died, in a very mysterious circumstances, after he was buried, the public made a lot of noise. The Director of Public Prosecution ordered the Inspector General of Police to do a further investigation. An exhumation was done, a second postmortem was done, and the matter is now in question court. Number 2, during the maandamanos and abductions, when there was a public outcry, the Director of Public Prosecution ordered the Inspector General to do further investigations and give reports to the Director of Public Prosecution within 14 or 21 days. Jirongo's death, we have seen the Director of Public, there's a lot of noise that it is not clear whether Jirongo, my client, died out of a normal accident or it was murder. The Director of Public Prosecution has ordered the DCI to investigate and give him a report. During the burial of Betty Bayo, the serious a musician who passed on. The family has raised an issue. They are not sure whether there was foul play. The Director of Public Prosecution has ordered the Inspector General of Police to do a thorough investigation and report back the findings to the Director of Public Prosecution. And if there is anybody who is culpable, the file to be presented to him to decide to charge. So the powers of the DPP are very, 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 very powerful. They can order the investigation. So today, you know, whenever there is an issue, if you have gone to the police and the police have not assisted you, you write a letter to the DPP and the DPP will order an investigation to conclude. Under these powers, there are very many complaints that you people have taken to the police stations. No action has ever been taken. Somebody has never been arrested. The police have never taken up the matter. You always go there, you are told, you will deal with it, you'll deal with it. Now you know. Write a letter addressed to the Office of the Director of Public Prosecution saying that you reported this complaint to the police. The police have never acted on the matter. The DPP will direct the police to act within a specified timeline so that the file is presented to the DPP. When I'm talking about the DPP is an office with very many prosecution counsels. They are called officers, the state counsels in the Office of the Director of Public Prosecution. Every court in this country, every criminal court has a state prosecutor called a state counsel representing the state or the office of the ODPP. They have delegated authority. So in your village there at the court, if the police have not done what they have done, write a letter to the ODPP office at the county level. They are at the sub-county level. They are at every court station. They are at the national level, that please the office of the ODPP to intervene. That is under Article 157(4). Let us see Article 157(5). The Director of Public Prosecution shall hold office for a term of 8 years and shall not be eligible for reappointment. So once the Director of Public Prosecution has been appointed, he has only one term. 8 years, he goes home. He cannot apply for reappointment again. His term is 8 years. 6. The Director of Public Prosecution shall exercise state powers of prosecution. The Director of Public Prosecution shall exercise state powers of prosecution. This is where I want everybody to understand. The police can, and I said it, the police are investigators. KRA is an investigator. EACC, Ethics and Anti-Corruption Commission, are investigators. The Immigration Office are investigators. They cannot be prosecutors. Kenyans said in Article 157, Article 157(6) says the Director of Public Prosecution shall exercise state powers of prosecution and may 1. Institute and undertake criminal proceedings against any person before any court other than court-martial in respect of any offense alleged to have been committed in this country. The DPP, the Office of the Director of Prosecution, can institute any criminal charge in any court of law. There are 2 courts of law in this country, a magistrate's court and the High Court. The DPP will institute charges in a criminal court. In a magistrate's court, he will draft what is called a charge sheet. We dealt with it when you are dealing with a trial. Court helicopter is given you can check on it. He'll do what is called an information to the High Court. A charge sheet is in the lower court. In murder trials, it is called an information. So he institutes criminal charges. The police will take the investigation file to the office of the ODPP. They will have the evidence linking this person to a crime. The DPP will look whether that evidence meets the threshold. The DPP has what is called the guidelines for the decision to charge. Has the evidence been satisfied? Does it have the public interest? The DPP will make a decision. Once the ODPP makes a decision, then that person will be arraigned in court. The police can never arraign anybody in court unless the DPP has approved the charges. EACC cannot arrest anybody and take them to any court of law in this country unless the ODPP has approved the charges as provided for in Article 157(6). 2. But the ODPP cannot take anybody in a court martial. What is a court martial? Under the KDF Act, this is the act that deals with the military. Members of the Kenya Army, members of the Air Force and Navy, if they make any offense under the military, they are not arrested and brought to normal courts. Unless they have killed a civilian, unless they have done an offense that touches on a civilian. Their courts are called court martials. It is presided over by generals of the army. The judiciary will go there to advise. A magistrate sits to advise the military. The military takes the decision. The punishment is not to take that person to a civilian prison. The military has their own prison. They will jail that person. The military has their own police called the military police. If you have seen the vehicles, there is the military investigating arm, not the DCI. They have the military police, not the general police. They have their courts called court martial. Those are the DPP cannot prosecute there. The prosecutor is a military officer. That is the first one. Number 2, the Director of Public Prosecutions shall exercise state powers in prosecution and may take over and continue any criminal proceedings commenced in any court other than a court martial that have been instituted or undertaken by another person or authority with the permission of the person, or authority. And so, under the Criminal Procedure Code, if the police have refused to prosecute, you can go to a magistrate's court. If the police fail to take action, you can go under the Criminal Procedure Code, Section 88. You ask a magistrate and say, I reported this incident at Central Police Station. For 10 years, that action has never been taken. I have gone to the DPP. Now action has ever been taken. Allow me to prosecute in my private capacity. The magistrate will allow you. You will take out someone, you will arrest and prosecute. the DPP has power to come and take over that matter. After he has taken over the matter from you in a private prosecution, C, he will say, under C subsection 6, C says he can discontinue at any stage before judgment is delivered any criminal proceedings instituted by the Director of Public Prosecution or taken over by the Director of Public Prosecutions under paragraph B. So the DPP can take over what is your private prosecution and proceed or discontinue. Get it very clearly, the powers of the DPP. Let us go to sub-article 7. If the discontinuance of any proceedings under clause 6 takes place after the close of the prosecution, the defendant shall be acquitted. What is the powers of the DPP under Article 157(8)? The Director of Public Prosecution may not discontinue a prosecution without the permission of the court. Many Kenyans have been getting this wrong. There is a lot of stories that the DPP has withdrawn matters of politicians. That the DPP has exercised the discretion to withdraw a matter. I want to be very, very clear. The DPP has no power to withdraw a matter. Under the Criminal Procedure Code, Section 87A, the law provides that the DPP can apply to court to withdraw a matter, but the court must agree. The court can reject. So the DPP, under the old constitution, and I want Kenyans to understand this, under the old constitution, there was what was called a nolle prosequi. The DPP could come to court, that time is the AG, and say, I've terminated this matter. The courts have no role. And that was the end of it. Under the new constitution, the DPP can decide to recommend to the court for withdrawal of matters. What can be the grounds that can make the DPP recommend withdrawal? One, the witnesses have died, so the DPP has no witnesses. Two, the witnesses have changed their mind. They cannot be traced, so the DPP cannot prosecute the matter. Third, the circumstances have changed. It was that time, it was right to charge under the public interest. For example, during the maandamano, the circumstances were to keep the country safe. Some of the people were arrested to bring order to the country. Some were charged with the offenses of terrorism. The DPP under Article 157(11), which we are going to read, reviews files every other time. If he reviews the file and finds that the evidence was weak, then he will recommend the file to be terminated. 4, the person was charged. Under the law, investigation is continuous. As somebody is in court, the file, the investigator is continuing to investigate. New evidence might be brought by the investigator to the DPP that this is the wrong person that we charged. The DPP, in upholding Article 157(11), will recommend the file, this case, to be withdrawn. Equally, there are very many reasons as to why the DPP can move the court for withdrawal. The DPP writes reasons to courts. It is not true that the DPP walks to court and withdraws the matter, he must give sufficient reasons as to why he must discontinue this matter. The DPP might have been told the accused person is dead. What will the DPP do? He must come to court and withdraw the matter under Section 87A that this person has died. So there are very many reasons as why the DPP has that power pursuant to Article 157(8). Therefore, the court will listen. If the accused person objects, his reasons will be put to court. The court will make a ruling. Very many cases, the courts can decline and the matter proceeds. But the question that is there, if the DPP is saying he has no witnesses and the court says the case will proceed, where will the DPP manufacture witnesses? So that is the reasoning that sometimes the magistrates reject, and I agree totally with the reasoning of the judgment of Justice Muteti, that if the constitutional office of the DPP has put it very clearly that it is me who brought this matter to court, I have evaluated this evidence, I don't have the witnesses, I don't think this matter is sufficient before this court, it should be withdrawn under Article 157 under Section 87A of the CPC. The courts can decide yes or no. If the decision of the court is no, normally the DPP moves to the High Court for revision to challenge that decision, and the DPP can go to the Court of Appeal and up to the Supreme Court on the question of withdrawal of matters. Those are powers vested on the DPP. Under Article 157(9), the powers of the Director of Public Prosecution may be exercised in person or by subordinate officers acting in accordance with general or special instructions. We have dealt that the DPP has officers called state councils who are in every court station, in every county, in every place in the Republic under delegated authorities. 10. The Director of Public Prosecution shall not require the consent of any person or authority for the commencement of a criminal proceeding and in the exercise of his or her powers or functions shall not be under the direction or control of any person or authority. The DPP does not get directions from anybody. He does not need the consent of anybody to prosecute. He does not need the consent of the police. He does not need the consent of Parliament. He does not need the consent of the President. The office of the ODPP is independent. He does not take directions from anybody, and therefore, even if the police take the file to the DPP, if the ODPP says it will not charge somebody, that is fine. If EACC takes a file to the ODPP, and you have seen every other time, ODPP carries files and says, we have submitted 300 files to the ODPP for prosecution. The ODPP's job is to evaluate evidence, to ascertain that the files presented before that office meet the threshold to sustain a charge in court. So the ODPP can reject out of 300, 250. You cannot challenge that. You cannot sue him. You cannot compel the ODPP. He has discretion on to decide to charge, to decide not to charge. So today, Kenyans should be very clear that under Article 157(10), you cannot give directions to the ODPP, but the ODPP and Article 157(4) can give directions to the Inspector General of Police. Article 157(11), and this is the most critical issue, the ODPP's mandate. The ODPP's mandate is in Article 157(11). What does it say? In exercising the powers conferred by this article, the Director of Public Prosecution shall have regard to the public interest, the interests of the administration of justice, and the need to prevent and avoid abuse of the legal processes. That the DPP at every single time, whenever discharging his mandate, remember, he is the link, the middle person. The investigator starts, the ODPP evaluates the evidence, he is the person who releases you to court to be charged. The consequences of an innocent person being charged, the DPP must protect. No innocent person should be taken to court. Investigators can investigate because of malice, because of you were asked to give a bribe, you refused, because of a lot of other issues. The DPP must look at that file properly. And once he sees the evidence, this is an innocent person being brought to court, he will preserve what he has been told. He must protect an abuse of the legal process. Political differences. Politicians who were in this party now are in this party can be arrested by the police and be dragged to court due to trumped up charges. The DPP will look at it and say, there is no evidence here to drag this person to court. We have seen people, policemen fighting for girlfriends with citizens in a bar. The matatu tout wins the heart of this beautiful girl. The policeman arrests the matatu tout, wants him to drag him to court. If you tell the DPP will look at that file and say, it was love, that the Makanga was considered better, and the DPP will not charge that Makanga who won the love contest between a Makanga and a policeman. So the office of the ODPP is not a conveyor belt by the police to arrest and take people to court. Very many of your people have been arrested on Friday. Then the files go to the ODPP. The ODPP declines and says, there is no offense disclosed here. Then you hear the OCS calling you and telling you, lete kidogo tuachilie mtu wako. You know very well the ODPP has refused to charge because there is no evidence to sustain that charge sheet. So today, you know, the critical role the office of the ODPP is there. The reason why the office has a security of tenure, a constitutional tenure, is to protect the public from an abuse. State agencies can be abusive. That is why the ODPP is insulated with that. And that is why there's only one office in this country that can do prosecution. Nobody else is allowed to prosecute anybody in this country. Two, he has to protect the interest of the administration of justice. The ODPP, his signature puts you at the dock. So every time you have been arrested, if you think you are arrested because you did not do what the police want, write a letter to the ODPP, explain why the ODPP should recall that file, look at it from your angle. Don't die in court, because the ODPP does sometimes don't know the circumstances that you are framed up. So if you are framed up, If the charges are trumped up charges, write to the ODPP. If you check at their website, you will find them. Every court has an ODPP officer called a prosecutor. Lastly, the ODPP is, if you look at the office of the Director of Public Prosecution, that is the only link that protects the ODPP, the police, from abuse of the legal processes. Wakili Danstan Omari, bringing it to you live and always wishing you a happy Christmas, Merry Christmas, a fantastic Christmas, and Happy New Year as we bring it to you. Next episode, the judiciary. What is this animal called the judiciary? We'll be dealing in the next episode. That is chapter 10 of the Constitution of Kenya, where we are looking at and dissecting the judiciary as it is. Thank you.